Members, let's continue. Let's proceed to Division 2. Now is Division 2, that is Section 26 to 28 in regard to ride-hailing vehicle certificates. Section 26, the Commissioner may, upon payment of $245, issue a certificate of ride-hailing vehicle, either in paper form or as an e-permit. Section 27, to facilitate law enforcement and the riding public, there will be a need for the display of ride-hailing vehicle certificates. According to 27(1), the Commissioner may specify the position and the manner of display of the certificate. If the permit is defaced or damaged, then the permit holder cannot use that particular vehicle. And of course, if the vehicle is not issued with such a certificate, then it cannot be displayed with a purported certificate issued for other vehicles. And also, the notice published under this subsection is not subsidiary legislation. Well, the reason why this is not subsidiary legislation for that particular Gazette notice issued by the Commissioner, we think that this is more technical in nature, so that the administration can adjust the relevant requirements for the display of the certificate appropriately. And it is the same as the requirement for the taxi fleet operations. The certificate must be displayed both on the screen shield as well as behind the vehicle, so that it can be easily identified by law enforcement officers. Some members, me included, earlier said that the display of the certificate should be in such manners that is conspicuous. And now you would specify that this is on this screen. Would that be other easy to recognize signs for the general public to recognize that this is a ride-hailing vehicle? Since you don't need to come back to consult us when you make amendments through another Gazette notice, please look into this. Yes, it was mentioned last time. We all agree that we should make it easy for the general public to identify a ride-hailing vehicle. But the vehicle concerned is also a private car, which the owner and his family members may use. So we have to consider both factors. We'll listen to the public comments when we proceed to the Gazette stage. Mr. Thomas. So there are two. Well, there is a certificate and there is a permit. A permit for the car owner, and the certificate is for the vehicle, which should be displayed. And when you talk about the content of the certificate, is it the same as the information in the permit? Well, there will be some differences. In the permit, there may be conditions imposed by the Commissioner, which are more detailed in nature. As for the certificate here, it's just a sign for easy recognition, and it will be displayed at the appropriate positions of the vehicles so that people know that this is a ride-hailing vehicle. So not all the information contained in the permit will be included in the certificate. Will the name of the owner be included in the certificate displayed? Can someone tell who the driver or owner is? Well, the certificate is in a certain color for easy recognition by the general public. But as for the question raised by Mr. So, when a ride-hailing vehicle is waiting for a passenger, how can the passenger knows that the driver is a permit holder? Well, the platform in providing the service to the passenger will indicate the license number of the ride-hailing vehicle as well as the driver. So this will be seen in the APP. People like to display something at the back of the vehicle, well, baby on car, etc. If the certificate, or if there's someone displaying something that looks like a certificate, which is not actually a certificate, that may cause a misunderstanding. What can you do in law enforcement? On the question of identification, there will be a QR code there. It will be a real-time information code so that the law enforcement officer can know that whether the vehicle is a vehicle with a license, with a certificate. I don't think they can try to they can display something to the same effect. Mr. Lam Wei Kwong, I said that the identity of the driver or permit holder will be disclosed by the platform operator. Is that in a condition in the permit, or is that going to be in the law? If we have something that really looks like a certificate, something that looks really like the signage required, and if you take a fare for payment, that of course will be an offense. But what if just displaying something that looked like a certificate? Well, whether it's a forged certificate, well, we can consult the police for their professional assessment as to whether that would be an offense. But a passenger must book the service through a platform. It's not that the passenger would see the certificate displayed and try to use the service directly.
Mr. Jonathan Lamport, I'd like to ask about 27.4 on the penalty. I'd like to see if I understand this correctly. A person can be liable to conviction to a fine at level 2 and to imprisonment for 6 months. But for a taxi driver, the fine would only be at $2,000 and no imprisonment. So why is there a huge discrepancy between the different penalties? Ms. Koch. Thank you, Chairman. Thank you, Mr. Lamport, for your question. When we set the conviction, we have considered the taxi fleet. When a taxi does not display the taxi fleet certificate according to Road Traffic Regulation 12U, then they are also liable on conviction to a fine at level 2. We believe that this is consistent. Mr. Chao Siu Chong, well, I follow up on a previous question. I'd like to first clarify that for a person not providing services yet still needs to display on a vehicle the vehicle certificate, would that actually be legal? Yes, thank you for your question. The vehicle, once receiving the vehicle certificate, would be requested to display this on a vehicle during operations, but it's not it's not a contravention if the certificate is displayed during non-operational period. Well, these are actually for two purposes. Can you actually ask the drivers not to display the certificate when it's for private use? So when it's a private vehicle, I don't think it should be legal to display the certificate. It may actually cause confusion amongst the public. The public may not know. And the driver may actually accept monetary compensation for providing services. I think it would be better to actually have the drivers not display the certificate during non-operations. Well, thank you, Mr. Chow, for your question. I believe that we spent some time discussing that in our last meeting. We are going to provide members with a written response on this very soon. Mr. Ip has mentioned that the person must display on a vehicle the vehicle certificate during operations. When service is not provided, even when the certificate is displayed, it is not a contravention of the law, because we did discuss last time that we must consider the road the circumstances on the road. We shouldn't require the drivers to remove the certificate, as it may not be safe. To confirm whether a vehicle is legally providing service, the certificate is not the only proof. We can also use technology to confirm it, and police officers can also see this information very clearly. A comprehensive response will be submitted to the Secretariat very soon. Thank you. Let us move on. Thank you. We now move on to Section 28. If a ride-hailing vehicle certificate issued in paper form is lost, the holder of the certificate may apply for a duplicate ride-hailing vehicle certificate in paper form, and this would be the same as the duplicate certificates. So some members asked how long it would take. Or as long as conditions are met, then the TD will be able to issue a duplicate vehicle certificate within 1 working day of the applications. Moving on to part 4 on drivers of ride-hailing vehicles, which is from section 29 to 37. On 29, for the purposes of section 55(x)(2)(c) of the ordinance, an applicant passes a driving test in respect of ride-hailing vehicles if the applicant passes a driving test under regulation 33 of Cap 374B. So when the applicant passes the driving test in taxis and ride-hailing vehicles, then the applicant would have passed the driving test for ride-hailing vehicles. Please wait, Mr. Jonathan Lamport. Thank you, Chairman. So does it mean that once you pass the test for taxi, then you would be eligible to also pass the ride-hailing vehicles? Because for the taxi test, the style is different because you have to know what to do when passengers flag down the taxis. But then for ride-hailing vehicles, it's mainly done via online. That might be a bit different from the traditional taxis. The major difference between taxi and ride-hailing vehicles is that the taxi drivers many refuse to use GPS, but then for the majority of ride-hailing vehicles, they would already have set the route on the GPS. So I want to know whether these two tests are the same. Ms. Kok? Oh, Commissioner, let me try to address this issue. There is now a current written test for taxis. So that would cover details of the taxi industry. Taxis and ride-hailing vehicle drivers would also need to know about operational knowledge. For ride-hailing vehicles, we would add more information on apps, on how to take orders and how to confirm orders. Drivers who have taken the test would also need to take a pre-operational course for ride-hailing services. Let me try to supplement. I understand your point, Mr. Lamport. Therefore, I must add to this. There are many e-maps. The consolidated test would include road safety and operational knowledge. We have already simplified many of the knowledge on destination to destination issues. And so the consolidated test is the first step. And there would be post courses. So for those who are interested in providing ride-hailing vehicles, and they could take some courses on that. As the Commissioner said, the ride-hailing vehicle service provider would need to take a course on how to use apps and technology. I hope that can answer Mr. Lamport's question. Thank you, Secretary. I'm a bit concerned about this because members of the public sometimes have arguments with drivers on which route to take and why wouldn't taxi drivers use GPS. with the issuance of this license and certificate. And when this is made clear, then the public will not have any arguments with the drivers. I just want to make this more ideal. Well, this is a very good comment. I think there should be more arrangements made so that taxi drivers could also learn to use apps and technology to reduce conflicts with the passengers. Mr. Chao Siu-chung, well, yeah, my question has already been answered. Thank you. Next. Thank you, Chairman. Section 30. According to Section 55X(2)(H), an application made must meet physical fitness requirements. Therefore, we are actually following Cap 374B bracket 10 on physical fitness requirements being applied also to ride-hailing platform drivers. Mr. Eric Yim. Thank you, Chairman. Well, physical fitness requirements are to be met. I also have concern about ethics. We have seen many cases of passengers complaining about sexual abuse or sexual behavior on the ride-hailing drivers. Perhaps you can also make sure that people with a sexual conviction record could be banned from providing ride-hailing services. Well, Mr. Yim, thank you for your comment and your reminder. You have already raised this issue in a previous meeting. We would consider the consistent criteria of applicants. Previously, we have said that for persons with serious traffic crime records, then they would not be eligible. We hope to take more measures to ensure that passengers feel safe when taking these rides. Recently, we have gone through it very carefully by requiring ride-hailing platforms to add in passenger safety requirements. Passengers could share their journeys to friends and family. There would also be a click to safety. When there are extenuating circumstances, the passenger requires help and support. This passenger can very conveniently and quickly seek help. Mr. Yim wants us to take a step further by checking the sexual conviction records. I hope you understand that in future we would consider to work with the police to explore how we can strengthen the checking of such records and to ensure that the drivers working on these platforms could provide safe journeys for passengers. We thank you for your comments and we will continue to improve. Thank you.
Mr. Lam Wei Kwong, on the physical fitness requirements, I would like to offer some comments. Previously, the administration said that for aged drivers of commercial vehicles, you may wish to impose stricter requirements. And now, since Category 3 drivers are exempted from that additional requirements, not like Category 3 drivers. Here, ride-hailing service drivers are Category 2 drivers. So would they be exempt from future, more onerous future requirements? Actually, the nature of the permit is that these drivers are commercial drivers of commercial vehicles. So in the future, if we have tightened up the physical fitness requirements for commercial vehicles, then the same would apply to the ride-hailing drivers. That's a very clear and specific. My question has been asked and answered. Let's move on. Section 31, form and content of ride-hailing vehicle driver permits, and the information to be stated there, validity period, name, etc. Next section 32, the validity period of the permit is may not exceed 5 days, and it will not be later than the expiry date of the applicant's full driving license. Section 32, bracket 3 is easy to understand, and that is the last day of the period of the permit. May not be later than the expiry date of the applicant's full driving license to drive a private car or light goods vehicle. That is to say, on your license is Category 1 and Category 2. So should we delete the words or light goods vehicles here? Or what is the rationale of having this additional limb of or light goods vehicle? Ms. Kwok, in the principal legislation, we have a requirement that the applicant must hold full driving license to drive a private car or light goods vehicle. So the wording here is in line with the principal legislation. In the past, a small minority of drivers holds only light goods vehicle. Yes, it's in the principal legislation. But last time when we scrutinized the requirement, we said it would be a transitional arrangement. And now since we have this owner-driver arrangement, and also it's only applicable to private car owners. So why can't we just take away the word or light goods vehicle, and it would be very easy to understand. Well, that would mean that in the future, someone who holds a Category 2 license would like to apply for a ride-hailing vehicle permit. Well, yes, you can directly take examination to get a Category 2, that is a good light goods vehicle driving license. But when it's passed, we will also grant a license for Category 1. So you are trying to make sure that you will not turn away drivers who holds only a number 2, category 2 license. Can you tell us, perhaps look into the number of this minority, this small number of category 2 license holder? Maybe there are only just a few, or perhaps it's because of the need to include them. Well, yes, as Mr. Chen has said, we can give you the number, but our inclination is that we don't want to exclude these light goods vehicle license holders because they have all the required skills. So we have to ensure fairness to them. The Bureau is inclined to keep this particular reference to light goods vehicle. Ms. Kwok, please continue. Section 33, renewal of ride-hailing vehicle driving permits. The application for renewal must be made in the specified form and way and must be made and there are some conditions to be fulfilled. That is, the applicant is a holder of valid full driving license and the applicant has not within 5 years before the day of application committed of some offense. And the applicant is a permanent holder of permanent identity, and the applicant is not required to pay. Is required to pay a prescribed fee for the issue of the renewed ride-hailing vehicle driving permit. Please continue. Well, the validity period is not more than 5 years, and it will not expire after the. It will not expire before the expiry of the driving license of the owner. And if there are changes to personal particulars, he has to inform the commissioner. Failing that, he may be subject to a fine of $5,000. Next, Section 36, the commissioner may, on his initiative or on application, vary a ride-hailing vehicle driving permit by updating any particulars stated in the permit. Here we have the same problem that the permit holder has to inform the commissioner in writing. So I hope you will consider my previous points as to whether this can only be done in writing. Section 37. A police officer or public officer authorized by the commissioner who reasonably suspects that a vehicle is being used in providing ride-hailing passenger transport service, he will be required to produce the permit. Failing that, the person commits an offense and may be subject on conviction, may be liable on conviction to a fine of at level 1, $2,000. I want to understand it a bit further. Now we issue e-driving license. So when a police officer or public officer asks for the production of the license, the driver can just use a QR code on the screen of a mobile phone. I wonder if in the future for the ride-hailing vehicle driving permits, it will be the same QR code combined with the driver's license particulars, or there will be two separate systems. Thank you for the members' expression of support of the e-driving license initiative. Well, in the future, there will be contained in the same app, but there will be a a different web page. So the permit will be shown on a different web page. Well, if we look at this from the perspective of a police officer, while providing ride-hailing service, the driver may have committed certain traffic offenses. The officer may ask the driver to produce the license and the permit. So the interface will first of all show the driving license, and then by pressing another button or going to another web page, there will be another code for showing the permit. So fine will be imposed if appropriate, but then another QR code will be shown to ascertain that he's a driving license holder and also a permit holder. Mr. Lam Wai-Keung, it said that serving taxi drivers will be automatically be qualified as permit holders. But future taxi drivers may need to take both examinations. So I would like to know the authority, the basis of the commissioner's authority to do this for existing drivers. Actually, for Category 1 and Category 2, the drivers, they can get endorsements on the mainland to drive Category 1 and Category 2 vehicles. And if people coming to Hong Kong and host Category 1 and Category 2 the driving license, can they work as a part-time ride-hailing service at the same time? So would there be additional requirements that the permit holder must be a holder of permanent ID? Mr. Lam Wai-Keung's point is important. Last year, when we examined the subsidiary legislation, we talked about that when you submit an application for ride-hailing service permit, the applicant must hold a permanent Hong Kong ID card, or holders of a non-permanent ID card who is not subject to any conditions of stay. And that will say only these people would qualify or would be eligible. And now Section 33 is on renewal. Therefore, in the 33 bracket 3 bracket C, you can see it's a similar requirement. And Ms. Kwok may wish to supplement. Yes, the Secretary's explanation is correct. When we amended the principal legislation, and we have a new Section 55X in the Road Traffic Ordinance, which contains a requirement that the applicant is a holder of a permanent ID card. So here, for renewal of the permit, is reiterated here that the applicant must be a holder of permanent ID card. Mr. Lam also raised another question that where's the authority for granting the permit to existing taxi drivers? Actually, it's the same section, Section 55X bracket 3, which stipulates that for the pre-service training and the examinations would not apply to existing drivers of a taxi license.
嗰個規例。
We now move on to part 5. Please wait. Legal advisor, I would like to ask whether there are issues raised. No. Okay. Now we move on to part 5. This is in relation to fees. According to section 38, if the commissioner refuses an application or a renewal, the commissioner must refund to the applicant the prescribed fee paid. Mr. Chao Siu Chong. Thank you, Chairman. I have a simple question. If the applicant withdraws his application, will there be a refund? So you paid, but then you decide not to go ahead. Would the refund be made? Do you have this information, Ms. Kwok? It wouldn't be refunded. Withdrawing the application would not provide a refund. All right, section 39. If the commissioner considers it in the public interest to do so, the commissioner may waive, exempt, reduce, or refund in whole or in part any fee payable or paid under Part 6A of the Ordinance or under this regulation. The legal advisor asked about this in paragraph 15. An example would be that the commissioner may exercise such power under exceptionally adverse circumstances affecting the rail-hailing service industry or the transport sector as a whole, such as during an epidemic. Now to part 6 on review by Transport Tribunal. We have taken reference from other regulations by the Road Traffic Regulation. Section 40. A person aggrieved by the commissioner's decision may apply in writing to the commissioner for a review of the decision by a transport tribunal. Section 41. If a person, in accordance with 55C, requires a review, the decision under review does not take effect until the application for the review has been regarded as being withdrawn or that the decision is confirmed or varied by the Transport Tribunal. Please continue. Section 42. The commissioner, upon receiving the application for a review, would fix a time and place for the review, and at least 14 days before the date of the review, give written notice to the applicant stating the time and place of the review. A transport tribunal may postpone the review if the applicant or his or her authorized representative does not appear at the hearing of the review and no written representation has been received, the application is to be regarded as being withdrawn. And for section 43, on a review, the Transport Tribunal must consider any evidence it received, whether tendered on behalf of the applicant or otherwise. The commissioner must give written notice of the decision, and the decision of the Transport Tribunal to confirm or vary the decision under review must specify a date for the purposes of section 41 bracket 2 bracket B, and the decision of the Transport Tribunal is final. Oh, some people may say that they did not receive the notice. If an applicant has already provided all communication means, could you actually send it via email instead of just by post? It could either be by email or by SMS. How does it work? Secretary, I understand your point. We have to take a look at this very carefully. We need to look at the Transport Tribunal procedures and arrangements. It is a review process which is legally binding. We have to scrutinize it very carefully internally to make sure that there will be no discrepancies. All right, please continue. Part 7. This is on miscellaneous items. Section 44, unless otherwise provided, the regulation does not affect the operation of any other enactment that applies to a private car or to a person who drives a private car. Section 45, reasonable excuse. Well, this section applies to a provision of this regulation that creates an offense, makes a reference to a reasonable excuse for a contravention to which a provision relates, and a defendant is taken to have established that the defendant had a reasonable excuse for the contravention if there is sufficient evidence to raise an issue that the defendant has such a reasonable excuse and the contrary is not proved by the prosecution beyond reasonable doubt. On paragraph 14 of the ALA's letter to see whether the new offences avail a defendant of a statutory defence of reasonable excuse. Well, it is our intent that a person charged with any of these offences can only rely on the statutory defences provided under the relevant provisions, and that the operation of the statutory defence of reasonable excuse that the defendant bears an evidential burden when providing the defence. In principle, the defendant bears an evidential burden when providing the defense, and where a statutory defense is inconsistent with the availability of the common law defense of honest and reasonable mistaken belief, then only the statutory defense can be relied on by a defendant. Any other questions? No, at the moment. Now we move on to section 46. The Commissioner may specify the form of a document required for the purposes of this regulation, or specify the way in which the document is to be provided, and it may also specify more than one form. All right, now to schedule of this regulation. Here it lists out all the fees, and when I was introducing the regulation, I think I have mentioned some of the fees. Let me go through this very briefly. Part 1, fees relating to ride-hailing service licenses, including an application for a license or application for extension of the validity period, and this would render a fee of $16,250 for extension of the validity of a riding service within 1 year would be 1.2 million, and the issue of a duplicate ride-hailing service license would be 1,510. Part 2 on fees relating to ride-hailing vehicle permits and ride-hailing vehicle certificates. The issues of these permits fees would depend on the period. If the period does not exceed 4 months, it's $540. If it exceeds 4 months but does not exceed 12 months, it's $1,560. If it exceeds 12 months, then it's $2,100. Issue of a renewed ride-hailing vehicle permit is $540 each time. Application for variation would be $1,500, and issue of a certificate would be 245, issue of a duplicate one would be 125. And for Part 3, fees relating to ride-hailing vehicle driving permits, the issue of a ride-hailing vehicle driving permit would be $82 for each period of 1 year. We have completed this part, and now we move on to the next part, which is actually to make changes to 373B, and this there are actually 16 sections, and the first one is on the effective date, which is starting from August 3rd of 2026. And then we have listed out 3 to 10 on the regulation amended, and this would actually be on page 1 of the marked up copy, which is on 374B to actually to include the test that the driving test in respect would be other than motorcycles, motor tricycles, taxi, or ride-hailing vehicles. And then on Section 4, page 2 of the marked up copy, which is to amend 374B to repeal taxi test, and then to add in the definition of the ride-hailing test. And now we move on to 5 and 6. I'm sorry, Mr. Chao Siu Chong. On the issuance of driver permit, in the main legislation, we said that there must be a course to be taken before services could be provided and a permit issued. I see in 374B on the road driving licenses regulations, there is no amendment to 8A. Is there a need to make an amendment to 8A? Mr. Yip. Thank you, Mr. Chow, for your question. On this course, last year when we handled the main legislation, well, on Cap 37410I, we have already added in the ride-hailing services. Therefore, we have already made it clear in our legislation last year. And the commissioner can also make relevant arrangements. I see 8A, well, for 374B, Section 8, on the courses for light good vehicles and public vehicles, there's also such a course requirement. Do you need to also add in ride-hailing service drivers? Let me try to add on to it. In the main legislation of last year, we have already amended 55X bracket 2 bracket D for those who apply to be a ride-hailing service driver. That driver must, a year in advance, complete all the courses required. All right, please continue. On 5, amendment of 5 to 6, that is actually in page 4 and 5 of the marked up copy. This is a technical amendment to just add in a title. So currently, we are going to divide into two parts, two divisions, part 3. So division 1 would be driving instructors and instruction, and division 2 driving tests, so that it will make it more clear. So we're just adding in 2 titles. I'm going to add 15 minutes to the meeting. All right, and then to marked up copy page 6, this is actually on 374B to add in 20A to state that the application of subdivision subdivision applies to any motor vehicle other than a motorcycle, motor tricycle, taxi, or ride-hailing vehicle, because for the motorcycle and motor tricycle, the driving tests are already listed in 374B from A to 12, and so we also want to rule out taxi and rail ride-hailing vehicle because it would be listed out in Part 2.
Now, Section 8 to 10 is page 8 of the markup copy, and there will be a combined driving test for taxis and ride-hailing vehicle drivers. So we have to repeal those paragraphs related to taxis, and then there will be new 28, and Subdivision 1 does not apply to the taxi or ride-hailing vehicles and motorcycle. Therefore, we are going to repeal the relevant paragraphs here. Now we are on Section 11, Section 11, Subdivision 2 to be added to Part 3, Division 2. Which page? Page 10 to page 13 of the markup copy. It is about driving tests in respect of taxis and ride-hailing vehicles. We have a subdivision setting out driving tests in respect of taxis and ride-hailing vehicles. Anyone who wants to take a driving test for both taxis and ride-hailing vehicles must make an application to the Commissioner. And also, after paying the relevant fees, there will be the issue of driving test forms by the Commissioner informing the applicants of the time and date of the driving test, and only holders of such a form can take the test. It's in line with the other driving tests. The legal advisor asked whether we need to specify the way the Commissioner notify the applicant of a driving test form. Well, to ensure consistency, so we need to specify the way the notice is, the applicant is notified under 33C. According to 33.4D, the driving test forms will be valid for 18 months from the day of issue. If the holder does not take the test on the specified date, the test will no longer be valid unless he has informed the Commissioner not less than 7 days in advance of his or her inability to attend the driving test, or the Commissioner is satisfied that the form holder was unable to attend the driving test due to circumstances beyond his control. 33 here is based on the existing Section 31(7). If the driving test form informs the Commissioner by 7 days in advance of the original driving test date, another date will be arranged in 7 days, and the holder will be informed of the new date of the driving test. 3F. This is based on Section 31(8). The Commissioner may cancel the driving test form and refund the fee paid. And we have this new 33F, that the Commissioner may refund the fee paid under certain circumstances. Next, 33G. This is page 13 of the markup copy. According to this section, the driving test in the future would be on 3 parts. That is, the person is conversant with the contents of road users code, and he possesses the knowledge required for providing service by using a taxi, and also providing ride hailing passenger transport service. And he's able to identify prominent places and the most appropriate routes when the service is rendered. Section 12, subsection 3 heading will be added to Part 3, Subdivision 2. And now here we are on page 14 to 15 of the markup copy, and this is about the amendment of Regulation 34. The magistrate can disqualify a driving license holder until he has retaken the test. And here we have the similar requirements or a stipulation of a retesting of driving license holders. This particular requirement also applies to hail riding permit holders. Next, page 16 of the markup copy, transitional provisions. This is section 14, and that is before the 3rd of August 2026. An applicant has submitted to take a driving test for using a taxi. Then he will be able to take the test under the old regime without the need to study for the updated, amended test requirements. 43C refers to the relevant fees for taking the taxi and hail riding license test. The legal advisor asked whether there should be a specific reference to section 33C. According to the latest drafting code, the cross-reference numbers will be at the section and subsection level and not to the paragraph level. Section 16, this is page 20 of the markup copy, is a consequential amendment. In the new 33G, there are new requirements on taking the driving test for taxi and ride-hailing service, so we need to repeal the existing requirement for testing tests to use taxi for service. And next, this is the next we have the power enjoyed by the Commissioner under the Section 55Q to publish through a public notice that the quota for rail hiding service vehicles is 10,000, and it will be take effect on the 3rd of August 2026. With regard to the notice, if at some point you want to issue more permits, you have the power to issue the permits or certificates right away. So my question is, the shortest time possible to issue more permits will be the time required to publish a Gazette notice. Well, the Gazette notice is subject to negative vetting. We have set the quota at 10,000. If in the future there's a need to adjust the quota, Since this is subject to negative vetting, it's a piece of subsidiary legislation. If it's an emergency cases, we would publish a notice, and then the vetting will come later. Well, so that's your statutory power. I hope through the questions and answers, the interested parties will know that you have the power to increase the quota very quickly. That's correct. And now we move on to the fourth subsidiary legislation, and that is a notice. It will be implemented in 2 stages. First on 55B, 55D of the Road Traffic Ordinance, and also the revocation of a vehicle license for offering service. It's a 13, 9, 12, 13, 14, 15, 16, and 18. It will come into effect on the 3rd of August 2026. And then right after that, the Commissioner may invite applications. And the other sections and stipulation will be take effect on the 22nd of August 2027. Questions? No? Well, we have been using the Chinese tests in our scrutiny. So my question for the legal advisors, what about the English test? Well, we examined the 4 legal notices, and there is no discrepancy between the Chinese version and the English version. So we have basically completed the scrutiny of the 4 legal notices. The deadline for scrutiny is the 15th of July, and notice should be given. If you want to move amendment, it's the 8th of July, and the deadline to make a report to the House Committee is the 3rd of July. So we would be getting a replies to questions raised by the public, and also questions raised by the members, and then I will decide whether we need to conduct a further meeting. I would like to thank all the government officials and members in attending this meeting today. Thank you.